Welcome to the Courtroom Action Channel. In this case, Petitioner Matthew Leroy Poe filed a motion to vacate, set aside, or correct his sentence after pleading guilty to possessing child pornography in the Southern District of Iowa. This video shows the hearing on Petitioner's motion.
We are convened in the matter of Matthew Leroy Poe versus the United States of America, number 12-353, on a motion to vacate, set aside, or correct sentence under 28 United States Code, section 2255, and this is an evidentiary hearing on that motion. It's my understanding that Mr. Poe is connected by telephone. Is that correct?
That's correct, Your Honor.
Mr. Poe, can you hear us all right?
Yes, there's a slight echo.
All right. If at any time you have difficulty hearing or understanding what people are saying in the courtroom, please let me know, all right?
I can do that, sir.
All right. This proceeding is being recorded pursuant to the special program that this court is involved in with cameras in the courtroom, and so we'll ask you to please keep distractions to a minimum, and this recording may be posted on the court's website or on the website for the administrative office of the courts as well. All right, Mr. Martins, I want to just let you know that we'd like a little bit of clarity added to it today as we go through the process, and it'll be up to you what you want to present in terms of evidence. But as we look through your claims, it's easy to identify some of them, but some of the material in the record, I'm not sure we understand whether they are separate claims or whether they are in support of the claim for ineffective assistance in not filing an appeal, basically arguing that these were issues that should have been discussed. So if you could help us know specifically and clearly what issues you are raising, what specific claims you are raising at some point in the process, I think that would be very helpful for us. With that then, are you prepared to present some evidence, sir?
I am, Your Honor, or I could give you a brief summary if you'd like.
That'd be fine.
Of what the claims are. Your Honor, as far as the first issue that we're presenting evidence on, it relates to when the letter was written to Steffi Tran by Matthew Poe requesting that his case be appealed. And so I think that that may be in dispute, but we'll have some evidence, I think, that will indicate to the court when that occurred. And then after that, Your Honor, we have an issue that relates to the concurrent versus the consecutive sentencing. And it is our contention, Your Honor, under 5G 1.3 on the in the sentencing guidelines that the court should have made his sentence concurrent. And the basis for that is the fact that he had an unexpired term of imprisonment that was on a state court sentence at the time that he was sentenced in federal court. We believe that because of the fact that the government had to use that prior sentence to get their five-level enhancement of his sentence guidelines, that would make that relevant conduct as it relates to the issues that are discussed in 5G 1.3. So if we have another offense in state court where the sentence, Your Honor, is unexpired, it's our contention under that provisions that it would be a situation where the court would have to have the sentences served concurrently.
And your basis of the argument that the court would have to is based upon the guidelines?
It's based upon the guidelines.
Okay. One of the things that I'll be interested in you addressing at some point in the process is why the guidelines there would be mandatory when the guidelines everywhere else are not mandatory.
Okay, Your Honor.
All right.
And then, Your Honor, the application of the five-level step-up, and it's based on a pattern of activity involving the sexual abuse or exploitation of a minor. And in that particular provision here, we have a charge that's based on child pornography and possession of child pornography. And so if we're going to have any application of that 5-level step up, it can't be based solely upon the charge in this case, on the possession of the child pornography. So then the question goes back to the relevant conduct issues. And then the court was not addressed with the issue of the concurrent versus consecutive sentencing at the time that the case was presented. And in reviewing, and we've presented to the court the sentencing transcript, and it indicates that there was no reference to that. Although I think the testimony of Attorney Tran will be that that was discussed between her and Matthew Poe. So Your Honor, I guess that would be a summary of where we're coming from on this case. And I think the issue, as far as relief that's being sought by Matthew Poe, would relate to the fact that he would request that the court re-sentence him and that they consider the issues of the concurrent sentencing option of the court in that hearing. So if that would be helpful to the court, I think would give you a summary of where we're coming from.
It is. Is your argument, Mr. Martins, that the 5-level enhancement was based upon the possession of child pornography as opposed to the prior criminal activity and a pattern of conduct?
Your Honor, it cannot be based on, it's our position that it cannot be based just on the possession of pornography.
Right.
I think
is it your position that's what it was based on?
I think, Your Honor, that they probably may have based that on the prior charge, in the Marshall County court, and they would have used that as relevant conduct to try to, make that a more serious offense in this case. So that's where we come from as it relates to our relevant conduct.
All right. So those 3 issues are the claims that you're raising?
Yes, Your Honor.
And then things like the mental status of Mr. Poe or his personal family background, and those things are just arguments in support of these other issues?
Yes, Your Honor.
All right. Thank you. That's very helpful. All right. You ready to present evidence, counsel?
I am, Your Honor. Your Honor, at this time, I would call Attorney Steffi Tran.
All right. Ms. Tran, we'll place you under oath.
Please raise your right hand. You do solemnly swear or affirm that the testimony you are about to give and cause now before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Take a seat, please.
Your Honor, before we begin, I think we both have a set of exhibits, and at this time the government, we both don't object to either side's exhibits, and at this time the government would move to admit exhibits 1 through 6, and I also have marked his petition as government exhibit 7, but that's in the ECF file.
All right. And Mr. Martins, do you object to 1 through 6 or 7?
No, we do not object.
All right. Those are received. Do you wish to offer some exhibits as well?
Your Honor, we've given a package to the court of the exhibits we intend to use, and that would be exhibits A through G, and we would offer exhibits A through G.
And no objection to those? All right. Yeah, exhibits A through G are also admitted. Thank you.
I apologize.
No problem. Would you state your name, please?
My name is Steffi Tran.
Are you an attorney?
Yes.
And where do you practice law?
My office, or?
Is your practice located in Des Moines, Iowa?
It is, yes.
And when were you admitted to the bar?
April 2004.
As far as the current case, Were you appointed under a CJA appointment to represent Matthew Poe?
Yes.
And what was the charge that you were working with him to defend?
It was a possession of child pornography.
Now, the issues in that case, did it relate solely to the possession of pornography, or were there any other issues or claims that it would have been some types of hands-on activity with children? Could you explain what the extent of the crime was?
It was just possession of children pornography.
At the time that you were representing Matthew, had he been sent to federal custody from the prison over at Oakdale, or I'm not sure if it's Oakdale or Newton, but to answer the federal charges?
Yes.
Did he still have a term of imprisonment that he was serving in state court under charges out of Marshall County at the time that you would have represented him in this court?
Yes.
Do you know what his sentence would have been in state court? Or?
I don't remember. I'm sorry.
You were aware, however, at the time you represented him that he had not served out that sentence?
That's correct.
Now, after Matthew was sentenced here in federal court, was he returned to serve his sentence in state court on the Marshall County charges?
Yes.
Now, Matthew pleaded guilty in this case. I assume that you had an opportunity to visit with him about the issues in his case, and you would have concurred with his decision or advised him as it relates to that guilty plea?
Yes.
At the time that he pled guilty, was there any kind of plea agreement with the government as to what his sentence would be, or what the government would recommend, or any sentencing or charging considerations related to his entry of his plea?
I don't believe so.
As far as his sentencing range, do you have a recollection of the range of sentences that the judge would have been faced with as it relates to his minimum and his maximum sentence?
Are you talking about prior to the enhancement, or?
No, let me ask it a different way. As far as his, what is the sentencing range under the statute that's applicable, the minimum sentence and the maximum sentence he was facing?
For the plea?
On the charge that he was going to be sentenced on. Would that have been 10 to 20 years?
That's correct. That sounds correct, yes.
Now, prior to Matthew being sentenced, he appeared in federal court for a plea taking, and I assume that you would have represented him at that plea taking.
That's correct.
Now, at that plea taking, was there a discussion of the sentencing range that might be imposed for Matthew as it relates to his charges?
Yes.
And do you recall the discussion that was had with the court about what that sentencing range would be?
I vaguely remember something about there was a mandatory minimum of 10 years, and that would have controlled.
Okay. So at that time, Matthew was thinking that his sentence would be 10 years or less?
Correct.
Objection as to what she knows Mr. Poe thought.
Overruled. Goes to the weight in this proceeding.
But Matthew was not expecting a 20-year sentence, was he, at the time that he entered his plea?
No.
Now, after his plea was entered, there was a PSI prepared. And what were the factors that drove up this sentence from your understanding?
Mainly, it was Mr. Poe's criminal history, and then there was some enhancement for, I believe there was an obstruction of justice, and then there was also a 5-point enhancement for the amount of pictures that he had. So mainly it was his criminal history and then some other factors relating to his case.
Did he also have a 5-level step up in that PSI for engaging in a pattern of sexual exploitation or activity related to minors?
I believe so.
When he appeared for sentencing in front of Judge Gritzner, do you recall the sentencing guideline ranges?
It was very high, almost twice what we were expecting.
Did you have a chance to discuss with Matthew Poe the reasons for that increase prior to him appearing at the courthouse for sentencing?
Yes, I remember visiting him at the jail.
And what was the nature of his reaction to what was occurring with his PSI? Did he understand what was happening?
He understood, but was very upset that the sentencing range was so high, given that we were expecting a minimum sentence of somewhere in about 10 years. So certainly he was very upset about the range.
Now, at the sentencing of Matthew Poe, or prior to that, had you ever given any consideration to a challenge to the increase of 5 levels that related to the pattern of activity involving sexual exploitation of a minor?
Yes.
And what were your thoughts in that regard?
Well, certainly my goal was to keep his guideline range as low as possible. But unfortunately, it was just, given Mr. Poe's criminal history, there wasn't a whole lot of room to work.
Now, you never made any challenge, either in objections to the PSI that you filed or at the sentencing, to the increase of 5 levels for pattern of activity involving sexual abuse or exploitation of a minor, did you?
I don't recall if that was made objection to the PSI, but certainly that was discussed in chamber with Judge Gritzner prior to going on the record.
And were you aware that that 5-level increase would have to be supported by more than just possession of child pornography?
I don't recall.
I think that it might require a pattern of activity that would involve more hands-on type of charges.
Well, certainly Mr. Poe was serving a state sentence for hands-on activity with children.
Now, one of the issues that I've raised on behalf of Matthew relates to whether or not the judge would have been directed, or at least a suggestion to the judge, under the provisions of 5G 1.3. It's a part of the sentencing guidelines that relates to concurrent versus consecutive sentences. Did you review that section of the sentencing guidelines to see if that might be applicable?
I don't recall if I did.
Your Honor, could I approach the witness?
You may.
Okay, all right.
I just handed you, and I'll give you a chance to read the section that I'm referring to, and that would be 5G 1.3 of the sentencing guidelines.
Okay.
Okay. Would it appear under this provision of the sentencing guidelines that there might be some direction given to the court related to a situation where you have an uncompleted term of imprisonment in state court as it relates to how the sentences would rerun as it relates to consecutive or concurrent serving of the sentence?
It appears it does.
And did you raise any issues with the court about the applicability of that part of the sentencing guidelines to this case?
Not on the record.
Now, at the time that prior to Matthew being sentenced, did you have discussions with him about the issues of concurrent versus consecutive sentences?
Yes.
And was it his hope that the judge was going to impose concurrent sentencing in this case?
Certainly it was his hope that it would run concurrently, but certainly I'm sure I had advised him that that is discretionary and that is entirely up to the court how he wants to run that.
Now, whether it was based on the provisions of 5G 1.3 or otherwise, I've read through the transcript of the sentencing in this case, and also I've read through the PSI and your objections to the PSI. Was the issue of the concurrent versus consecutive running of these sentences ever raised as an issue in any of those documents?
No.
Or your representation of Matthew Poe?
No.
Now, the PSI, I know that you had raised an issue on one of the upward step levels. I think it was a 2-level step up for obstruction of justice, and I think the judge had sustained Matthew's position as it relates to that issue. You recall that in the sentencing?
Yes.
And then as it relates to any other objections, was there anything else that you were raising as issues that should be considered by the court?
I'm sure that's in my objection to the pre-sentence report. I don't have that with me, I'm sorry.
Okay. Now, going back to what occurred at the sentencing, when you had the sentencing, Matthew received a sentence of 240 months, correct?
That sounds right, yes.
And after the sentencing, where was he taken?
He was taken up to the marshal's office area.
And did you go up there and meet with him prior to him being transported back to the Polk County Jail?
As a habit of practice, I always meet my client right after sentencing, so yes, I did.
And at that time, did you advise Matthew that you didn't see any issues that he could appeal?
Yes.
What was Matthew's response to you at that time?
He agreed with me.
Now, what did he tell you that he wanted to do as it relates to an appeal?
He did not want to appeal it. Certainly he was upset of the sentencing. I explained to him again, as the court did, why the level got so high, and he was fine with it. Certainly upset, but told me he did not want to appeal it.
Now, did you have any further face-to-face contact with Matthew Poe after your meeting with him at the Marshall's holding area following the sentencing?
No.
Did you have any telephone conferences with Matthew Poe after you had met with him at the Marshall's holding area post-sentencing?
I do not recall so, because that would mean I would have to take a collect call, and I make it a practice that I do not accept collect calls from clients.
So any communication with Matthew that you would have been in writing following his sentencing?
Correct.
Did you provide to the government a copy of the correspondence that you had with Matthew post-sentencing?
Yes.
Could I approach the witness, Your Honor?
Yes.
I'm going to hand you a set of the government's exhibits. Would this list of exhibits, or not the list of, would these exhibits comprise the correspondence that you had with Matthew Poe from your file following his sentencing?
I believe so, yes.
And when was the first letter that you received from Matthew Poe that you would have in your files have been received?
October 2nd, 2011.
And how much time would Matthew Poe normally have had to appeal?
14 days.
Now, if he was missing that 14 days, are you aware of whether or not he could have requested a 30-day extension from the court to appeal?
No.
I'm sorry, was the answer that the witness does not know, or that that he could not have requested an appeal?
Could he have requested an appeal after the 14 days if he got an extension of time from the judge?
I don't know.
Does the question assume that the request for extension would occur within the 14 days?
Your Honor, well, that's something that I'll have to review with the court. I'm not sure on that.
There's a rule. It's all right.
I know, Your Honor. And I think good cause has to be shown. So now, are you aware of when Matthew Poe was returned to state custody from the Polk County Jail to serve his state court sentence?
I don't know when he was returned.
Between the dates of August 4th of 2011, when Matthew was sentenced, and between August 15th, 2011, when I believe Matthew will testify he was returned to Oakdale to serve his state sentence, did you receive any letters from Matthew Poe requesting an appeal of his sentence?
No.
Now,
Counsel, just for the record, the October 2, 2011 letter, can we indicate what exhibit that is?
yes, Your Honor, that would be exhibit number 1.
Thank you. I assume so, but
Okay.
I think that'll be cleaner. Thank you.
Now, you went ahead and you apparently requested some transcripts for Matthew Poe.
Yes.
And as far as exhibit number 1, could you read the first paragraph of Matthew's letter to you or request to you on that letter that you have indicated is the first one that you have in your records after his sentencing?
Dear Steffi, I got the transcript. Thank you. I want to appeal the sentence. I want to try and give them back at least some of the 20 years.
Now, there must be another letter between the October 2nd letter and the time of his sentencing, because you had obtained some transcripts for him. Did you get a letter from him asking that you get that transcript for him?
I don't recall receiving any letter from Matthew. I do recall that as upset as he was when I went to see him after sentencing, that I know that he wanted to see in writing what happened, because I'm pretty sure he was upset. It was hard to digest how much time he actually got. So for some reason, I must have gotten the transcript and just sent it to him.
Or is it possible that he sent you another letter which is not still in your files?
That could be possible. But I don't have it in my file, and I have just about all the letters from him, including pre-sentencing.
How many letters did Matthew send to you? And I think you have those letters in front of you there on your desk in the covered government's exhibits, requesting that his sentence be appealed.
Requesting that his sentence be appealed? Well, the government exhibit 1, the letter of October 2nd, 2011, he said, I want to appeal the sentence. Then, should I just go ahead and say the government exhibit, Your Honor? Government exhibit 3, January 8th, 2012. Doesn't say anything about appeal other than that he wants his sentencing transcript and sentencing order. June 21st, 2012, Government Exhibit 5. I'm appealing my federal case. So with regards to mentioning appeal, I would say 2 letters.
Okay. Your Honor, I have no further questions at this time. Thank you.
Thank you. Cross-examination, Ms. Luxon?
Thank you, Your Honor. Ms. Tran, do you know what Mr. Poe was convicted for in Marshall County? I mean, I don't ask you to cite the Iowa statute, but in general, do you know what that conviction was for?
Basically, it was a sexual abuse on a minor child.
And when Mr. Martins asked you about, he asked you challenging the exploitation enhancement, the 5-level enhancement, you indicated that you didn't feel that you had a whole lot of room to work. Is that correct?
That's correct.
And why was that?
Based on Mr. Poe's criminal history, the amount of pictures that were involved, there wasn't any possible room for arguing that enhancement.
You, and I'm talking about the 5, not necessarily the enhancement for the number of pictures. I'm talking about the enhancement for the pattern of exploitation. Did you feel that you had any room to work to challenge that enhancement?
No, because Mr. Poe was currently serving state time for sexual assault on children.
You indicated that you discussed this in chambers. Was that prior to sentencing?
Prior to going on the record, Mr. Porter, myself, and I met with Judge Gritzner in his chamber.
And what was discussed about the exploitation enhancement, if anything?
I don't remember the exact discussion on that level enhancement, just generally with regards to the guideline range. Judge Gritzner was very clear that Mr. Poe will be receiving the maximum amount of time according to the guideline range.
And based on that discussion, did you believe that it would be helpful to challenge that enhancement or put any evidence on regarding that?
No.
Was there a discussion in, you indicated that you didn't raise the issue of concurrent versus consecutive sentences on the record. Did you raise it off the record?
In chamber with Judge Gritzner, yes.
And what did you indicate to the judge in chambers regarding the concurrent versus consecutive issue?
My request was that the court run the state sentencing with the federal sentencing concurrently. Certainly Mr. Porter was objecting to that, saying that he wants it to run consecutively. And based on Mr. Poe's criminal history, the court again reiterated that my client, Mr. Poe, would be receiving the maximum amount of time.
And based on that discussion in chambers, did you make a decision as to whether or not to raise this issue at sentencing?
Yes.
And what was that decision?
That it would not do any good to raise it on the record.
You had previously advised Mr. Poe that the concurrent versus consecutive issue was discretionary with the court.
Yes.
And is there a reason that you didn't object to this in your objections to the pre-sentence report?
I don't have a reason for that.
After sentencing, when you were talking with Mr. Poe in the marshal's holding cell, you indicated that he said he did not want to appeal. Did he give you a reason why he didn't want to appeal?
It wouldn't do any good to appeal it.
And is it your practice to maintain letters that you receive from clients in your file?
Yes.
Government's Exhibit 1 is the letter dated October 2nd, 2011, where Mr. Poe indicates that he wants to appeal his sentence. Is that the first indication that you had received from Mr. Poe that he wanted to appeal his sentence?
Yes.
And in Government Exhibit 2, did you respond to his October 2nd, 2011 letter?
Yes.
And you indicate that the time for appeal had run, is that correct?
Correct.
Now, in this letter, you stated that at your sentencing in July, Judge Gritzner informed you that you had 30 days to appeal. Was that a correct statement?
No, it was not. It would have been, his sentencing was August, and that he only had 14 days to appeal it. Unfortunately, I had mixed that time up with the state court appeal time.
And in any event, by October 14th of 2011, at the time you wrote this letter, that appeal time, the 14 days to appeal, had long come and gone.
Even if it was 30 days, it would have long gone.
And then Government Exhibit 3 is dated January 8th, 2012. And is he requesting, Mr. Poe's requesting a copy of the sentencing order and the sentencing transcripts?
Correct.
Would you have sent, and you indicated that you believed you had sent him transcripts on your own?
Yes,
Right after the sentencing.
that's correct.
Would you have sent any letter along with those transcripts?
Probably not. A lot of time, my letters, if it's not important or very informal, I just take an envelope, stamp my name on it, I pre-stamp, and I just handwrite the name and the address of who it goes to without any kind of letter, if it's just something I'm sending them.
So in January, he's requesting sentencing transcripts again. And this is Government Exhibit 3.
Yes?
Do you know why he was requesting those again?
I don't know.
And then Exhibit 4 is dated January 13th, 2012, and that's where you include a copy of the sentencing order. Is that correct?
That's correct.
And what do you tell Mr. Poe about the sentencing transcripts?
That Mr. Poe has to make a request with the clerk's office himself, and that I provided him the address of the clerk's office.
And then in June of 2012, Government Exhibit 5, is this another letter from Mr. Poe?
Yes.
And what does he request?
He wants his pre-sentence report.
Did you provide him with that?
I'm sure I did. Yes, I did, because I just handwrote on the letter that I received that I sent PSR 7/18/12.
And is that on the second page of Government Exhibit 5, which is a copy of the envelope?
Yes, and it goes back to how what I was saying earlier, is that I'm very informal because I have no support staff. I am it. So a lot of time I don't spend a whole lot of time on my letters.
Between August 4th and August 15th, 2011, did you receive any letters or any communication from Mr. Poe requesting an appeal?
No.
And the first time you received a request to appeal was October 2nd, 2011. Is that correct?
Yes.
I have nothing further.
Redirect.
No questions, Your Honor. Thank you.
You may step down. Is there any reason Ms. Tran needs to remain?
I don't believe so, Your Honor.
Thank you, sir.
I don't think Mr. Poe will take that long. If Ms. Tran doesn't have any other court, I might want to put her back on based on what he has to say.
I'm going to ask Ms. Tran to wait outside while we take any further testimony then. So Ms. Tran, will you step outside, please? Counsel, I think under the circumstances I am compelled to make a couple of comments. Ms. Tran has testified with regard to statements and comments that she believes were made in chambers, of course not on the record. She suggested that there was a discussion of the concurrent or consecutive sentencing. There was never an objection on that basis. The matter never came up, and frankly, I believe her testimony that something was discussed in chambers about that is not accurate. Secondly, with regard to the discussion of the enhancement for the pattern of conduct, I doubt very much, again, because there was no specific argument on that basis. I don't believe there was any discussion in chambers about that, and frankly, on a material issue of that sort, if there had been discussion in chambers, it would have been further disclosed in open court. It would not have been left in chambers off the record. And then lastly, she suggested that it was clear that the court was going to give Mr. Poe the maximum sentence. Frankly, I never would indicate such a thing in the conference before the hearing. I wouldn't do that before I heard the comments of counsel and any other evidence that was going to occur in the hearing, even if I anticipated that that might occur. Now, I may well have indicated that they had a tough road because of the criminal history, particularly the nature of the criminal history, but to suggest that the court indicated that the court would be giving the maximum sentence no matter what occurred in the hearing, frankly, counsel, that would never have occurred. Now, there are a couple of ways that you might address that. You might wish to, I don't know if Mr. Corder is going to be called or not. Mr. Corder would have been present as well, and perhaps his testimony could be enlightening on that subject without the court actually becoming a witness. But frankly, if I am a witness, then I think there is an issue as to how the case proceeds and whether I can preside on the case given what I've just indicated to you, because frankly I feel fairly strongly that the testimony Ms. Tran has given is just not true. Now, it may be because of faulty memory rather than intention to mislead in her testimony. I have no reason to believe that she was intentionally testifying falsely, but the suggestion that these matters were brought up to the court, it just seems to me is just simply not, it just simply can't be accurate. There would have been no reason to discuss these things given the fact that there had never been any objection based upon these issues. Now I have disclosed the hot potato is now back in your court, counsel, as to what you want to do.
Your Honor, we have no objections to you hearing this matter. As it relates to the comments made by Ms. Tran, you know, obviously her obligation to her client would have been to raise the appropriate issues on the record and to make a record of whatever was done in the sentencing. And so, you know, and she does not indicate, the record doesn't indicate that she did that. So, you know, I'm comfortable with proceeding and you know, I think that the issues that we've raised are independent of that discussion anyway.
Well, of course, these are sentencing issues that if the court had been alerted to their existence, the court necessarily would have, A, with regard to the enhancement and the calculation of the guideline range, would have to do that on the record. And B, with regard to concurrent or consecutive sentencing, the court would also have to disclose on the record any response to an objection in that regard. And so that's kind of where we are. Ms. Luxon?
Your Honor, at this time, I think I would ask that the record be held open after today so that I can have an opportunity. I attempted to contact Mr. Porter, was unable to get in before the hearing this morning, but I would ask that we be allowed to present an affidavit of Mr. Porter should it be different than what the court has said or indicated, and if not, then file a report to the court.
Mr. Martins, any objection to that?
Your Honor, you know, I have no objection to hearing from Mr. Porter. However, I would want to have an opportunity to visit with him also.
Well, and I think that's fair, and also to have an opportunity to file anything in reply. that the government were to file, and we'll leave the record open for that purpose. Obviously, it seems to me that from Mr. Poe's standpoint, what I have disclosed is actually favorable to him in that not only does the record not reflect these objections being made, but I don't believe they were made off the record in chambers either. So in that sense, unless Mr. Corder's recollection is to the contrary, then it seems to me that this is all fairly beneficial to Mr. Poe, or at least not damaging to him. And so I don't see any significant concern other than allowing you the opportunity to respond.
Your Honor, I'm not feeling that Mr. Poe is disadvantaged by the testimony of Ms. Tran regarding those matters in chambers.
All right. Well, Mr. Poe, have you heard all of this?
Yes, Your Honor.
Okay. All right. Well, we'll proceed on that basis. The record will remain open after this hearing for the purpose of submission of anything from Mr. Corder if it's deemed necessary and appropriate. And once that's done, within a week, I assume you wouldn't need more than a week to supplement if you feel you need to, Mr. Barnes.
Yes, Your Honor.
All right.
That would be sufficient.
Do you have further evidence?
Yes, I do, Your Honor. I would call Matthew Poe.
All right. Mr. Poe, you will be placed under oath by the clerk.
Okay.
Mr. Poe, please raise your right hand.
Okay.
You do solemnly swear or affirm that the testimony you are about to give and the cause now before this court will be the truth, the whole truth, and nothing but the truth.
I do.
Go ahead, counsel.
Thank you, Your Honor. Would you state your name, please?
Matthew Leroy Poe,
And what is your age?
34 years old.
Where are you presently housed?
United States Penitentiary Tucson facility.
And would that be in federal custody under the charge from the United States District Court for the Southern District of Iowa?
Yes, sir.
And how many years were you sentenced to?
20.
Now, Matthew, did you get
Excuse
a
me,
copy?
counsel, may I ask what has happened to Mr. Poe's state sentence? Have they paroled him to the federal detainer?
Yeah, Your Honor, they have paroled him to the federal detainer, and I have a timeline, which is Exhibit J.
Great, all right, thank
On your
you.
exhibits, and it'll give the dates that all of these
Then I'll
matters
stop
are.
interrupting you. Go ahead.
Matthew, as far as the offense in this case, do you have the exhibits which I sent down to you yesterday?
Yes, sir.
And then if you could look at Exhibit J. Can you find that?
It's in front of me, sir.
Now, the offense that caused your imprisonment in this case, was that back on March 11th of 2010?
Correct.
Now, I understand that you were not immediately arrested after that offense occurred.
That's correct.
And were you aware that they were even contemplating possibly charging you at that time?
Not until December of 2010. No, correction, 2011. No, 2010, excuse me. I'm not quite awake yet.
Okay. Now, Matthew, you were charged on an event which occurred on August 17th of 2010, correct?
Correct.
And that was in Marshall County?
Correct.
And then a felony charge for lascivious acts with a minor was filed against you on that date?
Yeah.
And from that date on, have you been held in custody?
Yes.
Now then, on February 10th of 2011, would this have been the date that you would have been sentenced in Marshall County?
Yes, sir.
And then the sentencing order, which was entered in that county, I believe is part of the record and the exhibits that we have in this case. Would that be correct?
Yes, my paperwork shows it is Exhibit C.
Okay. Now, after your sentencing in Marshall County, were you then transferred into federal custody?
No, I was taken to the IMCC Oakdale facility 1st that I was transported from the Oakdale facility to Polk County for the federal hold.
Okay. And would that have been on March 9th of 2011?
Correct.
Now, the sentencing in the federal case, was that on August 4th of 2011?
Yes.
And then after that sentencing, where were you housed?
Back at the Polk County jail.
And then when you left the Polk County jail, did you go into federal custody or remain there, or were you returned back to state custody?
I was taken back to state custody.
And would that have been on August 15th of 2011?
Yes.
Now, Matthew, at that point, did you start serving your time in state court on the
Yes.
state sentence?
Yes.
And where did you serve that time?
I've served it in a number of facilities. From Oakdale, I went to the Newton Correctional Facility. From the Newton, I went to the Clarinda Correctional Facility, where I was paroled out on March 6th, 2013, into federal custody.
Now, after I started representing you, Matthew, did I meet with you down at Clarinda?
Yes, sir.
And did I have some discussions with your counselor down there requesting that you be paroled to federal custody?
Yes.
And was that done by your counselor?
Yes.
Now, at present, you're in the federal prison in Tucson, Arizona. Was it June 28th, 2013 that you arrived there?
Approximately, yes.
Matthew, do you have a projected release date now for your release from federal custody?
Yes.
And what is that release date?
August 7th, 2030.
Now, Matthew, as far as the time that you have on this release, assuming that you would get a 15% reduction in your sentence for a good time, how many years would you have to serve?
I don't know.
Would that be around 17 years?
Sounds about right.
Now, I'm looking at the time that you've actually served in federal custody between March 6th of 2013, then your projected release date of August 7th of 2030. This would be about 5 months over 17 years, if I do my math correct. In other words, what I'm asking you is, have you lost any good time while you've been in federal prison?
No, sir.
Has it been explained to you why you're not getting a full 15% good time credit?
No.
Have you been given any time for the time that, any credit for the time that you would have been in federal custody while you were awaiting your trial or your sentencing in this case?
I don't know.
Okay. Now, Matthew, when you were being represented by Ms. Tram, where did you meet with her?
Initially or throughout the process?
Well, throughout the process.
At the Polk County jail.
And do you recall about how many times you would have met with her?
No, I don't.
Did you review with her the evidence that the government had and then make a determination that you were going to enter a guilty plea?
I remember discussing with her a guilty plea, but I don't remember any evidence.
Did she advise you that you should enter that guilty plea?
Yes.
Were there any plea agreements with the government concerning what they would make for recommendations or how they would handle the charging or handle the PSI issues? Was there any agreements of that type that you can recall?
Prior to the PSI, it was my understanding that the government would not seek the maximum term and would go for the minimum term.
Was that based on the colloquy that you had on the record in the plea proceedings before Judge Gritzner?
I do believe so.
And in that plea proceeding, was it represented by your attorney and by the government's attorney that your sentencing guidelines would be below the minimum sentence?
Yes.
And I believe that was on page 9 of the transcript of the plea taking. Now, when you got the PSI report, did you receive that while you were at the Polk County Jail?
Yes. Ms. Tran pointed out that the sentencing guidelines was higher than the max, and that I would not receive more than the max.
And was it your hope yet that you were not going to get the full 20 years?
Correct.
Now, did you have some discussions with your attorney, Steffi Tran, regarding the issues of concurrent and consecutive sentences?
Yes, it was my belief that she would ask for concurrent sentences.
And was there any discussion with her or any request for her that the court consider concurrent sentences at the time that your sentencing occurred?
Say that again, I didn't hear you.
Okay. At the time that your sentencing occurred, was there any requests made by Ms. Tran that the court consider the option of concurrent sentences?
No, there was not.
Was that something that had surprised you?
Yes.
Now, were you aware that under the law, that if the court does not mention concurrent sentences, that they're considered to run consecutively as it relates to state court and federal court sentences?
I wasn't aware of that until you were appointed counsel.
So even at that date, did you know until I was appointed as your counsel that your sentences were going to be required to be served consecutively?
No, I did not.
Well, Matthew, I would imagine that you were disappointed the date that you appeared for sentencing and you got the maximum sentence of 240 months.
I was dumbfounded, sir.
Now, after you had the sentencing proceedings with Judge Gritzner, where were you taken by the marshals?
Back to their holding area.
When you were back at that holding area, did Attorney Tran come up to visit with you?
Yes, sir.
Did she review with you any possible appeal issues you might have?
I asked her about an appeal. She said there was no grounds for it, so I didn't press the issue. I was still in a state of shock after receiving the maximum.
Of course, you're not an attorney, correct?
Correct.
And so as far as evaluating appeal issues, that was something that you needed some help with by your attorney.
Correct.
And at that time, you were not even aware that your sentences were going to have to be served consecutively.
Correct.
And this wasn't something that she had advised you of.
Correct.
Now, after you were at the holding area of the marshal's office here in this courthouse, where I'm sitting now, where were you taken?
Back to the Polk County Jail.
Now, when you left and this would have been on the sentencing date of August 4th of 2011?
Correct.
Now, how long were you at the Polk County Jail before they transported you to Oakdale to start serving your state court sentence?
11 days.
Now, I have asked you about dates that you would have sent a letter to Steffi Tran, the first letter regarding a request that your case be appealed. We've discussed that, haven't we?
Yes, sir.
And as we continue to discuss that, you did not know the exact date, did you? Excuse me, Matthew?
Say that again, John?
Oh, did you know the exact date that you sent your first letter to Steffi Tran requesting an appeal?
No.
Now, as you and I talked further, did you know where you were at when you mailed that request for an appeal?
I was in the special housing unit at the Polk County Jail.
And did you have her address here in Des Moines to send that letter?
Yes.
Now, Steffi Tran, in her letters that she produced in the court here, she had a letter which she says was the first one in her file, which was Government Exhibit 1, and it was dated October 2nd of 2011. Did you send her an earlier letter regarding this appeal?
Yes.
And also, had you made a request for some transcripts?
Yes. I don't
Now,
remember which transcripts, though.
And I don't see any, I see a reference in her Government Exhibit 1 letter on October 2nd of 2011 where you're telling her that, quote, I got the transcripts, thank you. Can you see that
Yes.
in the exhibits?
Yes, sir.
And so prior to your getting those transcripts, you had to make a request to her for those transcripts, didn't you?
Yes.
And now she tells me that she did not visit with you by phone and that she did not go to the jail to visit with you, so there apparently was a letter that you would have written her requesting transcripts.
Yes.
And in that letter, did you also tell her that you wanted to appeal?
Yes.
Now, how many days before you were transported to Oakdale and left the Polk County Jail do you think it was when you sent that letter to her?
Approximately 3 days.
So that would have been approximately 3 days prior to August 15th, 2011, at the time that you were transported to Oakdale.
Correct.
And did she provide transcripts to you?
Yes, she did. I don't remember which transcripts, though.
Okay. Have you had a hard time maintaining your written records in the various jails and prisons that you have been in?
Yes.
When you're transported to one place to another, do you oftentimes lose all your papers?
They come with you. Sometimes it takes a while to get them.
Okay. Now, all the paperwork that you had while you were in Clarinda serving your state sentence, I had to accumulate those papers for you from the prison, didn't I, after you left there?
That would be correct.
The papers did not automatically go with you.
No. For some reason, the federal system does not like transport property with the inmates.
Since that time that you wrote that first letter to your attorney, Steffi Graham, back in sometime between August 4th and 2011 and August 15th, 2011, has it always been your intention to appeal in this case?
No.
But you made a decision during that period of time to write her a letter requesting the appeal?
Yes.
Now, when no appeal was taken and you weren't hearing anything from her about that, did you write Judge Gritzner a letter
Yes, I
asking
did.
him for the appeal?
Yes, I told him that I was having a hard time maintaining contact with Ms. Tran. I wanted to appeal. Then he appointed U.S. counsel.
Okay. Now, the time that you would have written that letter to Judge Gritzner, that would have been after that 2-week period of time to appeal, would it not?
Correct.
And do you recall the exact date that you would have sent Judge Gritzner that letter?
No, I don't. I was in the Newton facility.
Without help from your attorney, were you in a position to know how you were going to pursue your appeal?
No.
There's been a number of legal issues raised in this matter, and you've relied upon my office to raise these issues on your behalf, have you not?
That would be correct.
I'm just reviewing my notes here, Matthew, to see if I have any other questions for you, so be just 1 second.
Okay.
Matthew, do you have any recollection of how many letters you had sent to Steffi Tran following your sentencing?
No, I don't. I know there was one when I was in Polk County Jail. Then there's at least 3 others.
Your Honor, I have no further questions. Thank you.
Ms. Luxa, cross-examination?
Thank you, Your Honor. Mr. Poe, you talked about at your plea hearing there was statements made by both Mr. Corder and Ms. Tran that they believed that your sentence, or that your guideline range would be lower than the mandatory minimum. Is that correct?
Yeah.
But you were also advised at that time by the court that the mandatory minimum would control over whatever the guidelines had to say, correct?
Correct.
And you had no written plea agreement with the government, is that right?
Correct.
And in your habeas petition, in your motion to vacate, set aside, or correct a sentence, you indicate in ground 1 that you sent 2 letters to your attorney requesting to appeal your sentence. Now, you've told us today that you sent one from Polk County within the appeal time. Is that your testimony?
Yes.
And when was the second letter?
On October 2nd, when I was in the Newton facility.
And did you keep a copy of any of the letters or make any type of a note of any letters that were sent to either Ms. Tran or the court?
I'm making a habit to keep a copy, but when I was in the Polk County Jail, I did not make a copy because I knew it wouldn't come with me.
And how did you know that?
They generally don't transport a lot of paperwork and a lot of inmate property from county jail to the state facility.
I have nothing further, Your Honor.
Redirect.
No further questions, Your Honor.
All right, thank you. Additional evidence, Mr. Martins?
No, Your Honor.
Does the
Oh, Your Honor, excuse me, one issue. Your Honor, I guess the letter that the court has received from Mr. Poe directly requesting the appeal, I don't know if that is in the court files. I haven't seen it, referenced on the PACER site.
It may be in a court-only file. Ms. Angeroth, have you checked on that? And I'm not sure if you have access to that either. I can, while we're proceeding here, I can ask my assistant to check on that and see if she can produce those for us.
Your Honor, I would like to offer that letter as part of the evidence in this
All
case.
right, let me... Does the government wish to present any evidence?
No, Your Honor, I have nothing additional to present. May I go let Ms. Tran know she may leave, or do you wish to have her remain?
She can leave as far as I'm concerned. I'll just see if we can get those letters produced for us here. Why don't we, counsel, if there's not going to be any additional evidence, why don't we just take about a 10-minute recess? We'll give the court reporter a break, and I'll check on those letters.
Thank you, Your Honor.
Thank you, Your Honor.
This concludes part 1 of 3 videos. Thank you for watching. Come back for more original courtroom action.